Oh, we are streaming. That's a word. We're streaming live now. Hello, everyone. Welcome to Legal Lunch and Learn, a weekly live show where we ask an expert your questions on a legal topic. My name is Cindy. I am a staff attorney here at Maryland Legal Aid. My co-host is the director of Community Lawyering Initiative, attorney Megan McDermott.
Hi, Cindy.
And joining us today is our expert on wills and estates, attorney Charlotte Ahern.
Hello.
Of course, our production engineer who is working in the background for us is Alec Chase. And Alec will also be uploading this video to YouTube after we finish the live recording here for those who do need captions. So today's topic is what to do when a loved one dies. So if you do have questions about this topic, please send them in the comment down below. We'll get them answered live. If you want to remain anonymous, you can direct message or private message us and we'll try to get your question in. And before we get started, just a couple of disclaimers. Just because you listen to our show and you take some legal advice here, it does not establish an attorney-client relationship between you and any of the attorneys that you see here today or with Maryland Legal Aid. So if you do have an immediate legal issue, please contact us. We'll put the contact information down in the comment section down below for those who need it. You can email us at lawyers@mdlab.org. That's LAWYER@mdlab.org or call us at 443-451-2805. All right, so with all that long introduction out of the way, hi Charlotte, how are you?
Hi, I'm great. It's so great to see you again.
Yeah, welcome back. Our first two-parter guest star.
I'm honored. I'm honored.
Bring us those ratings. So I think last time you told us a little bit about your background. How about this time? Tell us, and I'm sorry, I'm throwing this question at you. Tell us, what's something that you really enjoy about working as an attorney here at Legal Aid?
I would say probably getting to help people. We see a lot of different people, and sometimes we, can't help as much as we would like to be able to. But just being able to help at least, one person, whether that's just giving them brief advice or just helping them with paperwork or doing full representation, I'd say probably helping people is the number one reason I like working at Legal Aid.
Yep, absolutely. I tend to agree. I think it's working with clients, and sometimes, at the end of attorney-client relationship, if you will, getting to see our clients doing better in life, also just really helps us pushing through all our very heavy workloads here. So sorry to bring that back down to a somewhere depressing note. So let's talk about what happens when someone, a loved one, a close relative passes away. So let's get started. So I think very obviously when a parent or spouse passes away, there are definitely some documents that we do want to collect. So can you talk about, what those documents are and just point out a couple of important ones?
Sure. So we talked last week about certain documents like the will, the power of attorney, and the advanced medical directive. So if you know that your parents or loved one or grandparent or aunt or uncle did have a will, you should try to locate that will as soon as possible. If you're not sure if they had a will or not, you could try to check with the Register of Wills in the county where they live to see if maybe they registered their will. Another document that you would need would be a death certificate. That obviously shows that the person has, deceased and that they are a decedent. Any type of important, financial records or titles to property, whether that be real estate or a car, things like that. There's also any military service paperwork, anything that you think potentially could be important, I think is something that you should try to collect after someone passes away.
Yep. So in terms of death certificates, for those who don't know, and maybe if the death comes as a surprise, where might they go to get a copy?
No, great,
Sorry.
that's okay. there should be a vital records department in the county in which they lived, or in the county in which they passed away. I believe as well, like the Department of Health and Human Services. Sometimes we have had some clients that have had issues with death certificates before, but typically it's pretty easy.
Right. I think it's public records, right?
Yes.
Death certificates. Yep.
Mhm.
So let's break this down a little bit more. So let's say someone passes away and going to, if there's no will, but let's just say for a fact that there is a will. What do you do with it?
So you want to take the original to the Register of Wills in the county where they lived. You take that and the death certificate and any of those other documents that we just previously mentioned, and take it to the Register of Wills to open up an estate. If you don't have the original, you should try it, at first to find the original. But if you don't have the original, like I mentioned previously, you can check with the Register of Wills to see if it was actually registered there, because they should have the original if it was registered there.
Yeah. So, what if you don't have the original and someone comes up, also goes to Register of Wills and comes up with another copy, or maybe something that looks like original and it has different information on it? What happens then?
Well, you obviously you want to talk to all of your relatives and your family and your friends to try to figure out where the original is, and also to try to figure out which copy is the best copy. I will say, speaking of the Register of Wills, the clerks there are extremely, extremely nice and helpful. They're the best clerks out of any agency. So if you have any questions or if you have any issues, they should be able to help you. They can't give legal advice, but they can run you through all the documents and all the different paperwork. If you're having a problem with locating what you believe to be original, or there's maybe multiple copies of different types of wills, you can try to also run an estate search. That's through the Register of Wills as well, to see if maybe someone has already opened up an estate, because then you could try to get copies of documents through that. But if it's something where a lot of people are contesting what may or may not be the will, you should contact an attorney ASAP, because that can lead to a lot of problems.
Yep, definitely. So now let's go into what if there's no will. And I know we didn't really go over, what happens when you open an estate. Just sit tight, we'll get to it. So let's go to, so if I know this person did not leave a will, I know for sure, what would I have to do then?
So you still want to go to the Register of Wills and bring the death certificate and any other important documents that you need the death certificate. That way you can speak to the clerk and start the process of actually opening up an estate, and filing a petition to open up an estate. There's letters of administration and various documents that you would need to file in the estate, particularly in relation to appointing a personal representative. Because without a will, that means that there's no individual that has been given the duties of being the personal representative or the executor. People call it the executor as well. But getting the death certificate 100% and taking that to the Register of Wills is needed to open up an estate.
Can you explain what an estate is? I don't think we actually did the definition here.
So, I mean, it's basically a collection and of all the assets of an individual and all of the different documents that are needed to administer what's called probate. So there's actually two different types of a probate process. There's the administrative process, which is through the Register of Wills, and then there's the judicial process, which is through the Orphans Court, which is probate, but that's only if there's something that's contested or if there's an issue with the estate.
Right. So is there yep, just in case people are just so that people can be prepared, do you know if there's any fees attached with opening up an estate?
Yes, so there are fees. It depends on the size of the estate, whether it's a large estate or a small estate. Anything that's under I believe it's 50,000. The assets are under 50,000. That would be a small estate. But there is a kind of a exception to that with what they call the definition of poverty, which would reduce the fees significantly or waive the fees.
And of course, whoever goes to try to open an estate can talk to the clerks about that. I'm sure
Yes.
the clerks
Yeah.
will walk you through.
They're
All right,
very,
so
very nice. Very, very nice.
yes, we love good clerks. We appreciate their help for sure.
Yeah.
So you said something about a personal representative. So explain to us who can be a personal representative.
So if someone, obviously if there's a will, in your will, you would write, I would say, I want Cindy to be my PR. If there is not a
Please don't.
will, you
It sounds like a lot of work.
don't want to administer my estate, Cindy?
Yeah,
I thought you want to administer my estate.
I appreciate the thought. I appreciate it. But sorry, go on.
So anyone, I could name, and if I wrote a will, I could name anyone to be the PR. If there is no will, it's a familial family member relationship. So it's either a spouse that is still living, or it could be a child that is still living. It basically goes out from the family tree from that. But there are, exceptions to that as well. Sometimes creditors open up estates and appoint themselves as PRs, but that again, that's not seen as much. Usually it's the next of kin.
So when you say next kin, let me just throw this at you, because a lot of times, I think you might also be a culture thing, because we do this in the Chinese community a lot. A lot of times I will call a neighbor, my uncle, but they're not, biologically related to me, but they help bring me up, or they, and they pass away, and I'm, he doesn't have children, and I'm the only person who really knows him and who really cares about this. Would I be able to go open up in the state, or does it have to be someone who's related?
So again, depending on whether there's a will or not, I mean, he could have named you as his niece, but there's nothing really preventing you from petitioning to get letters of administration to be the personal representative. There are situations where that is contested. So say a living heir did actually come forward, they could then file a request for show cause to show why you shouldn't be the personal representative, and vice versa. If you wanted to say, oh, this other person isn't doing their duties, then you would have to show cause as to why they should not be PR.
So speaking of the PR or personal representative's duties, so what are those? So what does he or she do?
Sure. So when there's a will, they administer the will in accordance with the terms. And then if there's not a will, they administer the assets through what's called intestacy, the laws of intestacy, which is, as we previously discussed, familial relationships where you have heirs that go from spouse to children to grandchildren, et cetera, et cetera, et cetera. You are basically if you are a PR, you're basically the administrative person. So you're going to be opening up the estate, filing all of the documents, taking care of the fees and certain finances related to the estate. You're not personally liable for any certain monies. It can be paid through the estate, but you are the individual that is responsible for making sure that everything gets taken care of, essentially.
All right, and just to go through the process, do debts get paid first? If
Well, it depends, I guess, on if a creditor has come forward and made a claim. So the creditor has a certain amount of time to make a claim on estate. If they haven't made a claim on the estate, then they try to come later, say they come 10 months later, after the estate was opened, the PR, or depending on the circumstances, someone can file what's called a notice of disallowance, which says you're way too late for this claim. You can't file this claim. When it comes to things like taxes and funeral expenses and certain things like that, those typically do get paid first. But sorry, it's like annoying, complicated lawyer answer is that it depends, but it depends on what the debt is and if a creditor has actually come forward.
Right. So it does sound like being a peer is kind of being a peer is kind of really hard work.
It is and it isn't. I'm not trying to scare people. It is and it isn't. It depends on the size of the estate. I mean, obviously, sometimes I've said this to many clients before, where if you're Bill Gates or if you're somebody that has a significant amount of money, your PR is your attorney. Attorneys are PRs often because they pay them to do that. But if you have a smaller estate, it is actually pretty easy to navigate it on your own. Particularly because I can't say this enough, the clerks at the Registry of Wills are so nice and helpful, and they understand that everyone, this is a horrible time for people, just in general, but also when you're going through loss and things like that, they are very, very sensitive to that.
Yep. So I think earlier you said if you don't think the peer is doing a good job, you can challenge them. What if you don't want to be the PR yourself? Can you still bring up can you still challenge how the PR is, for example, dispersing the assets?
You should be able to. So challenging whether someone should be a PR versus challenging how an asset is distributed can be two separate things. Even though it's the PR that distributed it that way, that depends again if there's a will or not, or if there are any heirs, other unknown heirs that are living. If you don't like how an asset is being distributed, you don't necessarily have to challenge the PR, because it could be just an honest mistake. It could be that the PR actually didn't know. It's not that they're bad. It's not that they're not doing their duties. It's just that they didn't realize there was someone else that was living, or that, it should have been distributed in a different way.
Right. So if you think, a lot of times this comes out when people are like, oh no, I think I'm owed something from the estate. So if you think there was a mistake and you didn't get what you were going to inherit, what's the process here? What do you do?
You should consult an attorney. First and foremost, you should consult an attorney. I don't think legal aid helps with those particular types of issues, but we do have what's called our pro bono unit, which we pair individuals with volunteer private attorneys that will help you for free or at a reduced rate. So I do know that the pro bono unit can try to kind of hook you up with a private attorney that does do that. But if you think that you should be getting something in addition to, or if at all, from an estate, you should contact an attorney, because that can be challenging a will or challenging a particular asset can be a very arduous process.
Yep, absolutely. Sometimes made more arduous by the attorneys themselves, but
yeah.
But it is
not
definitely
us, though. Not us.
Not us. We are almost perfect in every way. So with that said, let's move on to some very common scams to watch out for. So obviously, when a loved one dies, you're extra vulnerable, and there are definitely people out there who are preying, who are predators, who are trying to take advantage of people who are grieving and maybe not thinking so straight, and at the same time have all these things going on in their lives. So I think earlier you mentioned that the PR is not liable for the debts from the estate. Can you expand on that?
Yeah, so personally liable. So I can't have my credit score affected by not paying a debt of my father's or something like that. Because that's not my debt. A creditor can't try to come after me if it's the estate or the decedent that owes the debt. However, if there is a creditor that makes a claim on the estate that is a valid claim prior to any distribution of assets or transfer of property or anything like that, that claim or that debt needs to either be satisfied or figured out in some way prior to any assets being distributed. So even though I'm not personally liable, I don't have to pay. It would be paid out of the estate. The debt would be paid out of the estate. It is still, if I'm owed some type of asset from the estate, you could make the claim that, oh, okay, well, I am paying it because it's out of something I was supposed to get, but at the same time, you're not personally liable for it.
Yep, absolutely. So afterwards they can't be like, hey,
Exactly.
the estate has run dry, now you pay. Right?
Exactly.
Yep.
That's the better way of putting it. That's the less complicated way of putting it.
And of course, I'm sure, I just want to let the listeners out there to know, of course, when you have, especially like a credit card company, they will hire people to tell you differently. They will hire people to say you are liable, even though you're not.
And that's a scam. Don't fall for that scam.
Do not fall for that scam. You're not, how do they put it? You're not responsible for the sins of your father or something like that.
Exactly. Yeah, exactly.
Yep. So along with that, do you know about, I think I do hear about funeral scams sometimes too?
Sometimes I have never, had that be an issue. But I know that it's a thing. I mean, I think if you know a little bit more about it, you could talk about it, but I've never personally seen that. But I've heard people talk about it. Basically funeral homes or alleged funeral homes, are trying to essentially take advantage of families when they're, like what you said, already in a vulnerable situation. So.
Right. For sure. Well, here's what I'll do. I'll actually post a link about your rights when it comes to paying funeral home fees. So basically, funeral homes can't really make you pay for anything beyond their basic fees for their, services, facilities, and coordinating the funeral. So I'll put a link in the comments after this so people can browse at their own leisure to see, what exactly they are responsible for. And it's sort of like it's almost sometimes like dealing with a car salesman. In certain circumstances, where I think funeral homes will say, you want this model of casket because that's what's recommended, or they say, well, you had to use this kind of casket because you're required by law, and that's just not true. The law doesn't tell you what kind of casket you have to use. So
this is a good plug for the fact that everyone should get a will, because you can say exactly what you want to have happen in your will in terms of your funeral arrangements. A lot of people figure that out prior to they don't have to put it in your will, but if you have a will, even if all you have is clothes on your back, and you can put your funeral arrangements in your will. So that way it prevent this scam from taking place.
Yep, absolutely. And of course, I think another scam that's also common is especially when you're potentially inheriting a property. I think another scam that's common is people will come at you and say you don't actually own this property that you actually inherited, and they make you sign away the deed.
Don't do that.
Yeah, don't do that. Always read where you're signing. Don't give away things. And I just want to do a quick plug here that we will actually be talking about deeds and different kinds of deeds actually, and owning a property later on in the series. And Charlotte, will you be I don't know if we got an answer.
Yes. Sure, I will.
I'm putting you on the spot there.
There are a lot of rumors out there about deeds, but like I told you, trust and estates and property are fraternal twins, so they're very much connected. There are tons of rumors about deeds. If anyone tries to ever come to you and say you should deed me your property, or write a quit claim deed to me, 1,000% consult an attorney, because that is not, if you don't know what the situation is, you do not want to be transferring assets out of your name for a number of different reasons. So if you ever have any questions about deeds or anything like that, consult an attorney prior to signing anything.
Yep, absolutely. And free help is out there.
Yep.
I know, like, a lot of times attorneys do take a lot of money, but there are also people who do this pro bono. So make sure you're getting the help that you need. So that's all the questions I have for before the show started. I'm going to go ahead and turn this over to Megan, who will ask you the questions that we gotten since the live has started.
Thanks, Cindy. Hi, Charlotte.
Hi. How are you?
Good. Thanks for all that info so far. So one question, do PRs ever make mistakes? Do things happen, for example, where they say that somebody else is owed an inheritance instead of the person that's actually been left to, and who monitors that?
So yes, we are humans, human nature. People make mistakes. Who monitors that? It depends on the situation. But as I mentioned previously, there's a difference between the administrative, kind of probate with register of wills, and then the judicial probate with the orphans court. So depending on what's happening in the estate, the register of wills can monitor that, but they can't really, it's not up to the register of wills to come forward and say, you didn't distribute this accurately. It would have to be somebody, else that's involved in the estate. With the judicial probate, it's a little different. The court can actually, or the orphans court can actually essentially assign a new PR and say, you're not doing this correctly. But again, that's not really required. It's really someone that's a part of the estate or that's an heir or beneficiary or something like that. You have the duty to come forward and say, hey, this is supposed to come to me, not this person.
So if you suspect that the PR has done something wrong, you should notify the court. You can't expect them to just pick up on it. Is that right?
I wouldn't expect them to pick up on it. Depending on the size of the estate and what's going on with the estate, they probably would. I mean, if it's a larger estate that's being contested and it's already in orphans court, then there's already issues going on, so it is being monitored. But I would not rely on that at all. I would come forward and say, I'm either writing a caveat to this portion of the will or to the PR, or do a show cause as to why that PR needs to be removed because of the fact that they did X, Y, and Z.
Okay. So you and Cindy touched on this a little bit, but I think a thing that happens a lot with clients and questions that they have, a parent passes away and their adult child was living in the house with them, and then they don't do anything official. They just keep living in the house, and they write a mortgage check, and that's it. So what does that mean for them? Does that mean that they own the house? What do they have to do to make sure, that they're on the deed and that they're on the mortgage? Yeah.
So this can go in a million different ways, but the basic, if somebody passes away and you are in a property, and you believe that you're the only heir, or that you and maybe your brother or sister are the heirs, and you're having issues with the mortgage company, contact an attorney. That's number one. Contact an attorney, or contact legal aid to see if you're having any issues with foreclosure. But mortgage companies, they don't care who's paying the mortgage. They'll accept the money from anybody. It doesn't have to be the heirs. But if the person has a will, obviously the property needs to be transferred to whoever it should be transferred to, depending on what the deed says. If you are already on the deed as a survivor, as a joint tenant, then the actual deed to the property already gets transferred to you. It's up to the mortgage company. You can try to contact the mortgage company to assume the loan, but that's up to the mortgage company to see if you qualify. But even to communicate with the mortgage company about the mortgage of the decedent, there has to be an estate opened and you have to be the PR. I can't just call up a mortgage company and try to get information about, somebody's mortgage that's dead, that I have, you have to show that there is, that you have the authority to speak on behalf of the estate. And to do that is through being the PR. And once you get they're called the letters of administration. When you're the PR, I would ask for, through the register of wills, I'd ask for like 6 or 7 copies so that you can then give that to the various creditors and debtors and mortgage companies, et cetera. Does that's a very convoluted answer. But these things get very complicated, so you should contact an attorney, I think, is the number one thing.
So the mortgage company won't just transfer the mortgage to you. You have to go through
No.
to refinance the property.
You can try to refinance, you can try to assume the loan, you could try to do a loan modification if you're already kind of in foreclosure. But again, they're only going to talk to you if you have the legal authority to speak on behalf of the estate, which that would be going to the Register of Wills, opening up an estate, becoming the PR, getting the letters of administration, and then providing them to the mortgage company.
Okay. So what happens if, say, my parent leaves me the house in their will, but that's the only property they have? There's nothing else in the estate, so there's no assistance. There's no money to help me pay for the mortgage, and I don't think I can afford the mortgage. Is there anything I can do, or am I going to have to sell that house?
That's complicated as well. And this also applies to the previous question that you just asked is, so the State Department of Assessment and Taxation, assesses a property's value every single year. If there's a mortgage for a property that's it still owes $50,000 and you're in arrears for however much, but the property is only being assessed at $6,000, it doesn't really make sense to try to keep that asset because it's not worth the amount that's on the mortgage company that is owed. So, I mean, that can get kind of into the weeds. So it just depends. It's not you don't really have to do anything. I mean, if you have no sentimental connection to the property or whatever, you can just walk away. Obviously, we want people to keep assets in their family. We want wealth to grow and things like that. But if it's a situation where it doesn't make sense because the property isn't worth that much, then you could just walk away.
Okay. So you guys talked a lot about home ownership, but we also have a lot of clients who are tenants and their parents are tenants as well. So what happens if my parent dies in the middle of their lease period for their apartment? So they die in June, but they signed a lease through December. Do I owe that rent? Do they owe that rent after they pass? How does that work?
So this can get complicated too sometimes, but generally I will say, obviously it depends on what the lease says. And the example that you just gave, there's still a significant amount of time left in the lease. A lease doesn't automatically terminate just because somebody passes away. However, most landlords, in that circumstance are pretty, understanding. You also need time if you do, depending on how long a person lived in that property or what the circumstances are, they might have a lot of stuff there. So we don't really want there to be an automatic termination because there's still property in there that you need to go through, whether it's sentimental or photos or whatever it may be. So a lease doesn't automatically get terminated just because somebody passes away. However, it's similar to a debtor creditor situation where a landlord would then have to make a claim on the estate for whatever rent they think that they're owed. You can always negotiate with the landlord and say, hey, my grandmother just passed away. She's lived here for 5 years. Can we write some agreement where I have 2 or 3 months to kind of get all the stuff out? And then that would, obviously I would say a lawyer should look that over as well to make sure that everything's, above board. But most landlords in that situation, I would hope, would be pretty reasonable and understanding.
Okay, great. Thank you. Well, that's all the questions I have. So we'll bring Cindy back to wrap things up.
Yay.
Yay. All right. So now we're at the end of the show. What is, like we did last time, what is, let's say, the most important thing you would like our audiences to know about what to do after a loved one dies?
That's a hard one.
Besides getting a lawyer, because
I would say getting
probably
a lawyer,
should if they can.
Lawyer, attorney. I would say trying to locate a will if there is one, because that can clear up a lot of different questionable problems that could potentially happen in the future. And then that's number one, probably, is trying to locate a will. And number two would probably be, if you can't locate a will, take the death certificate to the Register of Wills, and they have so much information. I've never had a bad experience with any of the clerks there, and that's, I think saying a lot from, and I work primarily in Baltimore City. They're so nice, and they're very, very, very helpful.
Yep, absolutely. Well, thank you so much for that. And hopefully, listeners out there, hopefully this helped. And I know it's a very grim topic. So next week, we are going to be talking about veterans benefits. So audiences, if you do have a question about veteran benefits, please leave a comment down below or email us, or you can private message us as well. And of course, remember, if you do like this video, or if you think there's some good information in here, make sure you share this video, especially with your family members. And of course, tune in. Excuse me. My speech is just going all over the place today. Tune in next Tuesday at noon, same time, same place. And that's pretty much it. Have a good weekend.
Okay, thank you. Thanks for having me again.